I just wanted to take a few minutes to say welcome to our Baker Botts offices. We're very glad to have you here. We have two sets of panels that are going to be very interesting, and the first one is of particular interest to us because it's going to be presenting our second annulment project on ICSID and non-ICSID annulments. And I give the word now to Jose Antonio.
Thank you, Maria Carolina, and thank you, Baker Botts. Thank you, Jennifer, and thank you for everyone that has contributed to putting this together. All the arbitration team, which I know that goes beyond Jennifer and Maria Carolina. So thank you all. I would like to introduce this panel, but before, 1 second, because here we are. Before introducing David Turner, I would like to emphasize that when asked, I mean, some of you might have heard this from me before when we were planning this year's set of panels for the 6th edition of Washington Arbitration Week. There came a question from one of the advisory members, shall we do a subject matter topic, why not sports arbitration or art or this or that? And I said, well, first ICSID is here, and the topic, the natural topic, is investment arbitration, but we'll go way beyond that. We have from the inception included international commercial arbitration, as well as public international law, and in many respects issues related to enforcement of arbitral awards, both arbitral awards in commercial as well as in investment arbitration. The topic of annulment is a key one, which in investment arbitration in ICSID cases is one very much sought for by pretty much everyone in the arbitration community, from counsel, arbitrators, funders, etc. So it's a key topic from the substantive perspective to how the review in the beginning of the annulment proceedings was perhaps expansive, to say the least, and how that has become somehow more restricted, but also from a statistical perspective. So it is my great pleasure to introduce David Turner, who has come from no other place than London just for this panel and just to see you. I'm not kidding. David is an experienced practitioner and advocate in international arbitration, litigation, and public international law, with particular experience in investor-state arbitration. He has acted as counsel in numerous international disputes under the ICC, LCIA, ICSID, SCC, TIAC, ICDR, and UNCITRAL arbitration rules. A dual qualified English solicitor, advocate, and New Zealand barrister and solicitor, from New Zealand.
I did come from London.
I know. David has worked in the United Kingdom, the United States, New Zealand, and Australia. Prior to joining Baker Botts, David clerked at the Supreme Court of New Zealand and served as legal advisor to leading international arbitrations, Sir David William KC. So with you, David, and he will introduce the other panelists and more into that with the topic.
Well, thank you very much, Jose Antonio. So welcome everyone to the first Baker Botts panel of the afternoon. As Jose Antonio just mentioned, this is a bit of a special panel in the sense that it commemorates the forthcoming launch of the second study prepared by Baker Botts together with BICL, the British Institute of International and Comparative Law, on annulment proceedings. So the first study was published in 2021 addressing specifically ICSID annulment proceedings. We like to say, I believe it's correct, that it was the first empirical study to be done assessing the data that has been produced at ICSID about annulment proceedings, and really, digging into the data about the frequency of annulment proceedings, the frequency of success, the various grounds, and crunching the data on that. The second study, which is actually being formally launched next week in London with Bickle, has broadened the scope. The second study updates the data on ICSID annulment proceedings, but it looks beyond that too. So folds in a comparison of investor state annulment and set-aside proceedings in national courts around the world. So both comparing that to the data from ICSID and also comparing between different national jurisdictions, looking at, again, at the frequency of success, the bases on which that takes place, that kind of thing. So this afternoon is actually a bit of a hybrid format. We're going to hear first from Jack Biggs, who's, I think, down the end of the table, my colleague from London. He's a senior associate at Baker Botts, who will be presenting a sneak preview, if you like, of some of the findings from the forthcoming report. And then after that, we'll be joined by my esteemed panel here to discuss the implications from some of the findings that Jack is about to present. So I'll save the introduction of the panel until after Jack has presented. So without further ado, let's give the floor to Jack to present some of our initial findings.
David, thanks very much. Good afternoon, ladies and gentlemen. So we're here to talk about annulment. So as a starting point, I think we can all agree it's a very important, though increasingly common, part of investor-state dispute proceedings. And as David mentioned, our first study really focused in on looking at this empirically from, looking at ICSID. And as he said, we've kind of broadened the scope a bit now for our second study, with the purpose of looking at, not just looking at the updated figures of ICSID annulment, but also what happens when you go before national courts. Because as we know, ICSID isn't the only forum for investor-state dispute settlement. And so we wanted to kind of get an idea of, okay, what are the advantages, disadvantages of selecting different seats for investor-state dispute settlement. And so with that in mind, as our figures that you'll see today are as of 1 August 2025. And what we've done, as you can see on screen there, we've reviewed 231 ICSID annulment proceedings and 169 non-ICSID investor state annulment proceedings across 16 jurisdictions. But again, as you can imagine, there's a heavy concentration in a small number of jurisdictions. So for the purpose of today, I think there's 6 main jurisdictions, if you want to use that term, that we'll be focusing on in terms of the results that we have. So turning first then to annulment in ICSID. Again, I know, I'm sure we're all very, very familiar with this. The drafters viewed it as an exceptional remedy. Okay, there's obviously plenty of debate as to whether that is perhaps the scope may have broadened, and again, we can leave that for the panel discussion to follow. But the key point to remember, obviously, is that under Article 52, as you can see on screen, there are ICSID annulment is limited exclusively to these grounds. And the reason I point this out is because, as I'll highlight in due course, the grounds before most national courts are significantly broader. And so it's very important to consider that when you compare the figures that you have before state courts vis-a-vis what you have before ICSID ad hoc committees. Okay, very different grounds. And so with that in mind, as I said, we've identified 231 completed or ongoing proceedings of 504 awards rendered, and 45.8% of ICSID awards have been or are currently subject of annulment proceedings. And then within that, of the 140 completed annulment proceedings, 25 have been annulled in part or in full. So the headline number here is a 17.9% success rate. So then one important point to remember is, okay, well, then what happens if you are successful? As you know, you do have the option then for resubmission. And what's interesting actually is that a majority haven't. Only 48%. And as far as we're aware, only one case, the first Klockner case, sorry, the second one, in which the resubmission led to a more favorable outcome than the first. But for those who've been following the news, you would have seen that a number of the most recent successful ICSID annulment applications, so Rockhoff of Italy is obviously one well-known example, has been resubmitted. A number of others have as well. So it will be very interesting to see if that number grows and if the resubmitted arbitration proceedings provide the same or potentially more successful outcomes than the first. So then who is seeking to annul? You'll see here that states seek to annul ICSID awards more often than claimants, although not by much. Investors are more likely to prevail. And you'll see down the bottom again, perhaps no surprise in terms of the most frequent applicants. And again, there's obviously very different reasons. For those of you who are familiar with the intra-EU objection, obviously Spain certainly feels compelled to seek annulment of any awards, whether it be before national courts or ICSID. And so there's obviously different reasons why states do seek it. What is interesting though is we looked into this, and in terms of, the most recent ICSID case statistics as of 30 June 2025. And we found that in terms of all ICSID decisions up until that point, 49% of tribunals had upheld claims in part or in full. Of the other 51%, 29% of the tribunals had dismissed the claims, 20% of the tribunals had declined jurisdiction, and 2% of tribunals had ruled that the claims were manifestly without legal merit. So on that basis, there was a 51-49% split, just, you might say, in favor of states. But what's interesting is that when you look at the numbers up on the screen, there's a 64-36% split when it comes to who's actually seeking annulment. Okay, and so states are far more likely to seek annulment than unsuccessful investors. So the breakdown. As you recall, there are 5 grounds, and as you can see, the numbers on the screen are split accordingly. Again, I don't think to anyone in this room it will come as any surprise which grounds are more frequently invoked than others, and by extension, which ones are most successful. So obviously ground B, the tribunal being manifestly exceeding its powers, where there was a serious departure from a fundamental rule of procedure and a failure to state reasons, are by far the most commonly invoked grounds for ICSID annulment. Now, to put those numbers in perhaps a little bit more context, when we look at manifest excess of powers, it has been raised in 77.9% of all completed annulment proceedings, and as flagged on the previous slide, has a success rate of essentially 12%. Now, within those 13 successful applications, as you can see on the screen, 5 related to jurisdiction, 6 related to whether the tribunal had applied the applicable law, and 2 related to other tribunal powers. Similarly, a failure to state reasons has been invoked in 75% of ICSID proceedings with a 10.4% success rate, and then a departure from a fundamental rule of procedure is slightly back with 64.3%, but only a 5.6% success rate. Now, one important point, which you'll see on the next slide, is that obviously there's been a significant increase in ICSID in ICSID arbitrations, but also in annulment applications in recent years. And so you'll see on screen here, that significant uptick in applications is also mirrored in annulment decisions. But again, as you can see from that gap, what it goes to show is that there are always a number of decisions that are proceedings that are discontinued. So whether for tactical reasons, for example, if a party decides, well, we're not sure if we've got a good case, let's initiate annulment proceedings, and then perhaps we'll settle, or perhaps we don't think we have a particularly great case, so we'll no longer pursue it for whatever reason. There is, as you'll see, quite a large gap in terms of the annulment decisions and annulment applications. And then again, unsurprisingly, perhaps the number of successful ICSID applications, despite that significant rise in applications, has risen at a very gradual rate. So to put that in context, if we look at this from 1 January 2020, there have been 205 awards rendered since then, and 84 have led to annulment applications, 41% application rate. But then of those 84 annulment applications, only 4 have led to a full or partial annulment. But perhaps critically, of the 30 completed applications, 4 have led to a full and partial annulment, which is a 13.3% success rate, which, as you will recall, is a lower success rate than the overarching rate that we have in the entire lifetime of ICSID annulment. So some concluding marks on this part of the study. Annulment remains rare. Okay, of the 146 completed applications, there is a 17.9% success rate. But as I said, that low success rate does not discourage parties from initiating annulment. Okay, those proceedings, whether, as I said, legally obliged to for tactical reasons or for any other reason for that matter. While states seek to annul ICSID awards more often than investors, investors are actually slightly more likely to prevail. And as we said, it was grounds B and E regarding the manifest excess of powers and a failure to state reasons, which are 2 of the 3 most commonly invoked grounds and successfully invoked grounds, I should add, for ICSID annulment proceedings. So that's what we have so far for a snapshot, I suppose, of ICSID annulment and the success rate and other statistics. Let's then turn to what happens when we face national courts. How does that differ in terms of their approaches? So as I noted from the outset, most national laws include far broader grounds for annulments than what you find under the ICSID Convention. So notions of arbitrability, public policy, and perhaps most crucially, de novo review of jurisdiction. Because obviously when you go before an ICSID annulment committee and you are seeking to challenge the decision on jurisdiction, right, you don't just have to show that there was an excess of powers by failing to uphold jurisdiction or incorrectly declining. You have to show it's manifest, right? You do not have that threshold before most national courts. And not only that, you have de novo review where for certain national courts, you can bring up entirely new arguments that were never raised before the tribunal, entirely new evidence that was never raised before the underlying tribunal. And so what we've seen is that has had a material impact in the number of successful applications before national courts. And in terms of when you look at what are the main differences between ICSID and non-ICSID annulment, that would be, we would argue, one of the main differences for parties seeking to annul awards. Now, as part of our study, obviously while there is parallel and crossover, jurisdictions frame obviously their grounds of annulment in slightly different ways. In order to try and harmonize it, what we have done is come up with 7 grounds in terms of trying to, categorize everything between jurisdictions. So the first, ground 1 being when a tribunal has wrongly upheld or declined jurisdiction, failure to present its case. Ground 3, an excess where the tribunal has exceeded its jurisdiction or failure to comply with its mandate. Ground 4 relates to the composition of the tribunal. Ground 5, the subject of the dispute was not capable of being resolved, so arbitrability. Ground 6 is public policy, and then ground 7, if you didn't fit into any of the others, we popped it into ground 7, any other ground. And so with that in mind, as I noted, we had reviewed 169 completed. Of those 169 across 16 jurisdictions, 48 awards were annulled. So you have a success rate, a global success rate of 28.4%. And as I said, that compares to a 17.9% for ICSID annulment applications. But as you'll see, the value of this global rate is quite limited because the success rate before different national courts, different jurisdictions varies huge, very, very significant gap or differences between jurisdictions, both in the success rate and also the approaches that they take. And so that global rate is perhaps, has a bit of an asterisk next to it, I suppose. Now, what this data, I think, highlights is the importance of the seat, because, as I said, different courts take different approaches. And the other point to flag from the outset is that, similar to ICSID annulment, there has been a significant increase in both the number of annulment applications in the last 10 years, and in certain jurisdictions, a significant increase in the number of successful annulment applications. So, briefly now go through 6 of what you might call the main jurisdictions in terms of how they've approached this. So, turning first to England and Wales, where there's actually a 56.3% success rate. Now, granted, to recall, this is only an investor state dispute, so this is not including the annulment processes or applications in relation to commercial disputes. But it's nevertheless quite a striking number. Now, as I'm sure you all know, the English Arbitration Act is the relevant framework here. And under Section 67, there is ground to review lack of jurisdiction, and then obviously under Section 68, you have serious irregularities. Now, one important point to note is that the English Arbitration Act was recently amended, revised, and one of the revisions that was made is a slight narrowing of the scope of review under Section 67. And so you no longer can now raise entirely new arguments or raise new evidence. You can only really raise what was raised before the tribunal. And so that will certainly be something interesting to look for, looking forward, is if that has any impact at all on the success rate of parties when they're invoking Section 67 before the English courts. France, we have 41 completed proceedings where there was a 34.1% success rate. But what's interesting about the French jurisprudence on annulment is that, unlike certain jurisdictions where, for example, the English courts, most of the successful applications related to decisions on jurisdiction. And as you'll see in due course, most of the successful applications for the Swedish courts related to the intra-EU objection. The French situation is slightly different because there's actually quite a split in terms of what parties have successfully been able to invoke before those courts. So, as you may be aware, there have been 2 successful intra-EU objection applications, both against the state of Poland. There's also been a number of jurisdictional decisions and other decisions regarding the procedural irregularities of the underlying proceedings. Next up, we have the Netherlands, where there's a success rate of 11.8%. And what's interesting is that the Netherlands, like, to be fair, the French and the English courts, they also have de novo review of jurisdiction. But as you can see, despite, so as you can see on the screen, that hasn't actually translated into much success in the same way it has before the English courts, for example. And one, I think, other point to note here is that although you've had 2 successful applications, only one of those was actually, you might say, a decision that went all the way through to a final judgment, and that was Naftogaz v. Russia. The decision in Khan Energy in India was set aside, but that process was not actually challenged by the state. So for all intents and purposes, really, there's actually only been one successful, you might say, application in a sense, in terms of the Dutch courts concluding that an underlying award should be annulled. Sweden. Here we have, like the UK or the English courts, sorry, you have above 50%. But what's interesting here is that of those 13 successful applications, 8 of them have been based on the intra-EU ISDS objection. Some of those have been framed on the basis that the underlying dispute was not arbitrable, but most of them were decided on public policy grounds. So the Swedish courts concluded that intra-EU investor-state dispute settlement was fundamentally contrary to EU law. And then on that basis, if it was contrary to EU law, it must by extension be contrary to the fundamental principles of Swedish law. And then by extension, the Swedish courts have repeatedly concluded that that constitutes a breach of Swedish public policy. Switzerland is next, and this is the jurisdiction with the lowest success rate. And I think what's also interesting here is that obviously with the Netherlands and the English courts, the sample size was not particularly large. I think we had 17 decisions for the English courts and more or less the same for the Dutch courts. The Swiss courts, there is obviously a much larger sample size here. And you only have, as you can see on the screen, one successful application. Again, like many of those other jurisdictions, the Swiss courts have the ability to review decisions on jurisdiction de novo. In fact, they've been invoked on 20 occasions, and only once, in Corrix in Venezuela, has that application been successful. In fact, as you can see on screen, it's the only time anyone in the ISDS context has successfully invoked an award before the Swiss courts. One, I think, other point of interest with the Swiss courts, and to be fair, I think you could say the same about the English courts, is the intra-EU ISDS objection has obviously been raised for the Swiss courts, raised for the English courts. And what is very interesting is just how dismissive they've been of those arguments. So perhaps unsurprisingly, in the same way that there's perhaps a great deference to those arguments within the EU, or the French courts, or the Swedish courts, the Swiss courts in particular have actually been quite dismissive. So if you are interested, obviously the decision in EDF in Spain is a good example of that, where they essentially said, this is of no relevance to us, we'll move on. And so again, in terms of particularly, I think, for parties that are looking at disputes from an intra-EU perspective, we certainly expect to see Geneva selected as a seat of arbitration, perhaps more frequently in the future. And so again, time will tell. And then finally, the United States. As far as we're aware, and I'm sure we'll be corrected if we're wrong, given that we are obviously in the US, there have been 11 completed non-ICSID investor-state annulment proceedings before the US courts, and hasn't been a successful annulment application. Now, again, as you can see on screen, there's the split in terms of between states and investors more or less the same. But again, a clear difference with the overall rate of non-ICSID jurisdictions. So to put all of this into perspective, up on screen, you can see now, I guess, a comparison in terms of the number of applications or proceedings before different jurisdictions and the success rate between those. So in conclusion, annulment applications are unlikely to succeed in ICSID proceedings. And obviously the success rate has dropped despite a significant increase in applications. Overall, annulment applications before national courts are, as I said, at a global level, significantly more likely to succeed. Although, again, as we have discussed, it does vary widely between jurisdictions, despite the fact that, as I said, most of those jurisdictions do have quite similar grounds, right? Public policy can be invoked, de novo review of jurisdiction, arbitrability, and so forth. But despite that, there has been a significant difference in the success rate between those jurisdictions. And so that brings us to the end of those findings. I think as David flagged at the start, we're hoping to release the actual study itself in December. And so obviously we'll be very happy to share it with anyone and everyone that's interested in it. And so without further ado, I hand over to my colleague David to lead this panel. Thank you.
All right, thank you, Jack. So as I mentioned, for the second half of today's event, we're going to have a discussion with our panel here on the findings, some of the findings that we've just seen. Before we kick off, just to introduce our panel, they probably need no introduction, but just in case, immediately to my left is Chales Kotuby. Chales is of counsel at 3 Crowns here in Washington. He's also a professor at the University of Pittsburgh School of Law, an honorary professor at Durham Law School, and a visiting professor of law at the Kiev School of Economics. He's also a member of the US government's delegation to the UNSA Trial Working Group number 3 on reforms to investor-state arbitration, and a member of the US State Department's Advisory Committee on reforms to investor-state settlement. So sounds like he can't have much free time amongst all that. Chuck also teaches on international arbitration, public international law, and international human rights, and has published extensively, co-authoring or authoring more than 24 articles and book chapters over the last 20 years. So that's Chales. To Charles's left, we have Lucinda, of course, founding partner at Low and Kinnear Dispute Resolution and a highly sought after independent arbitrator. Lucinda has had a storied career in international arbitration spanning some 40 years now, having cut her teeth before the US-Iran Claims Tribunal, before going on to serve as a partner at Steptoe & Johnson here in Washington for around 20 years. Lucinda chairs the board of directors of the Coalition for Integrity, formerly known as Transparency International USA. She's also a member of the Secretary of State's Advisory Committee on International Law, a former president of the American Society of International Law, and a former chair of the ABA section of the International Law. So another panelist with a lot of free time. Lucinda has also served on ICSID's panel of arbitrators and is a member of the ICC's Commission on Arbitration and ABR. So we're very fortunate again to have Lucinda here to share the benefit of her considerable experience in arbitration with us. And last but not least, we have Ramos-Mrosovsky, who's a partner and co-leader of the investor state arbitration practice at Baker Hostetler. Carlos is also the chair of the international section of the New York State Bar Association and has been recognized as a rising star by all of the leading directories, including Chambers, Legal 500, and Lexology. Carlos acts for both investors and states in investor-state arbitration, as well as international commercial arbitration, with an emphasis on disputes in the energy, mining, and infrastructure sectors. And he also appears before the US courts regularly on matters involving award and judgment enforcement, discovery, sovereign immunity, and cross-border assets recovery. So I'm sure we'll agree, a very esteemed panel. So let's kick off, perhaps starting with you, Lucinda, looking at some of the findings that Jack's just presented. So I guess one of the headline findings from ICSID was, as Jack explained, that annulment proceedings have around an 18% success rate, meaning that almost 1 out of every 5 awards that is challenged through the ICSID process is either partially or fully annulled. So I guess my first question is, does that figure surprise you? Does that seem high, low, or perhaps just about right?
Well, first, let me say thank you to Washington Arbitration Week, to Baker Botts for hosting, and congratulations on your survey. Really very interesting, and I think it underscores for all of us the value of having these empirical efforts conducted. So we look forward to the final unveiling, but happy to get a foreshadowing of what's to come. I would also flag for this group, there's some ICSID tools and information that are useful here. ICSID published in 2024 an updated background paper on annulment, which is the history, the rules, lots of things, but it has some very interesting data and statistics in it as well. And I think, before I answer your question, what I take away from all of this, I mean, yes, there's been an increase, but it's in a context of more cases, more intense litigation, maybe higher stakes. So on a certain level, it's not surprising that there would be an increase in the number of challenges. Now, coming to the success rate, I mean, I think, again, let's think about it a little bit in context. Obviously, the vast majority of cases of applications are rejected. And we shouldn't lose that point. A significant number are discontinued. About 25%, by my calculations from the ICSID paper, I didn't have access to all your data, but about 25% are discontinued, either at the request of one or both of the parties through a failure to act or through a failure to pay the costs of the proceedings. And so that's what the whole universe looks like, which takes me to the question of that you posed, David, is the number that you've come up with, or ICSID comes up with, which is in any case a small minority, high, low, or about right. Now, as Jeff pointed out, annulment is intended to be an exceptional remedy. And tribunals, at least in my experience, are very competent and careful. So frankly, if the percentage were high, that would shock me a bit. That would show that there's something really malfunctioning in the system. And remember that the convention grounds we're talking about don't include things like public policy or errors of law. Annulment is not an appeal. I'm not surprised by the increasing incidence of recourse. We'll, I think, come to the tactical element of these that may come into play as well. So I won't get into that. But I do note that the applicant seeking annulment has to advance the costs of the proceeding, unlike the proceedings before the initial arbitral tribunal where the costs are shared. And so I think we would actually need to dig a little bit deeper to really understand what's going on here, to understand why cases are abandoned, why, if some are resolved. I think it's interesting, the lack of success on resubmission. So I guess my bottom line is, no, it doesn't really surprise me when you think about it in context, but it makes me curious to know more.
Well, as you just touched on, Lucinda, so not only do these applications have an 18% success rate, which is holding fairly stable, but the number of annulment applications overall, as Jack explained, is increasing over time, which would tend to suggest that although more annulment applications are being filed, more of them therefore are being rejected or discontinued. Jack's figures showed that around 46%, or nearly half, of all annulment arbitrations are now resubmitted, if you like, to annulment proceedings afterwards, for what, again, as we've said several times already, is meant to be an extraordinary remedy and not simply an appeal as a matter of course. So perhaps, Chales, for you, is that figure a cause for concern, that effectively half of all arbitrations at ICSID end up in annulment? Does that show that the procedure is being abused, or again, is this how you think it should be applied?
I think these numbers are distressingly high. And I'll take issue with what you said. And I think just to put out a counterpoint, I think we really need to think about this and discuss this in real terms. Let's be honest, ICSID isn't constituting panels improperly. There's never been upheld an allegation of corruption. So are we to believe that there's a credible case that nearly half of the tribunals chosen by the parties are exceeding their powers or committing serious error? And then almost 1 in 5 have done so. I mean, if that's the case, then we have a big problem that we have to look at. And if it's all just a strategy of delay, cloaked in a procedural right, we have an equally big problem. Let's think about this from 30,000 feet. Now, I've represented both states and investors. I would say the vast majority of who I've represented have been investors. And, you know, are we to ask them to spend $10 million over 5 years on a legal process, after which it's almost more often than not, there's going to be another process before 3 other individuals from a list that's primarily put together by the defendants, where the matter will sit for another 1.5 years and has a 1 in 5 chance of forcing to start over. What sane investor would do this? What sane funder would fund it? I think that if we do see a drop off in ISDS cases in the future, this is going to be partially why. There's certainly some tactics at stake, but I would prefer to see, you know, much lower numbers in all of this, especially on the filing front. I think half of cases going up is there's something afoot here, and I think that's a cause for concern. That's just my 2 cents. I'd be curious to hear your reaction, though.
Well, I don't know that we want to get into a full-fledged debate, but I do note that applications are often accompanied by a stay in enforcement of the underlying award, and that a high percentage of those are granted. So I do think tactics, gaining time, especially when large awards are involved, plays a major role.
A major role. Yeah.
So why do you think it is then that, given that the likelihood of success is so low, that both investors and states continue to apply at such a high rate? Is it simply a tactical issue? Is it just, as you suggested, Lucinda, to create delay, perhaps to buy some time, or is it perhaps that investors and states are not aware that the rate of success is so low, and so they're not making a fair calculus about bringing an application?
I mean, I think the statistics are out there for everybody to see. That doesn't mean that hope doesn't spring eternal in the heart of the losing party, that this is the one that's going to break through. I mean, I take Charles's point that there is increasing litigiousness around this. I'm not sure you could devise any system where that wouldn't be the case. And the half, or the 46%, don't go to final adjudication. Obviously, as I said, 25% at least fall by the wayside. That's still a significant percentage.
It is
still a significant percentage. But I think it's a combination of reasons, and that combination is the stakes, tactics, a genuine belief that they got it wrong. And I think there are a lot of people who don't fully understand the ICSID annulment scheme or resist it on a fundamental level. I mean, those grounds, the first annulment case I did gave me headaches trying to wrap my head around some of the grounds and figure out, okay, where's the line between appeal and annulment? How does, you know, when is a failure to state reasons, when does that cross over into something that's more like errors of fact or law? It's very tricky. It's very tricky. And so I think it's a mix of reasons that lead to the increasing incidents that we've seen. I don't think you can ascribe it solely to one factor. And I'm just not ready to conclude that it's a huge problem in the system as Charles apparently is.
Carlos, a question for you. You've acted on both sides of these disputes for both investors and states. As Jack's findings show, states are significantly more likely to seek annulment of an award, even though the outcomes in ICSID arbitrations tend to be about 50-50. Why do you think it is that states are more eager to at least file an annulment application, although not necessarily always see it through, from your experience?
Well, firstly, let me thank you as well for having me here, and say what a pleasure it is to be here. And thank you both for that very concise and informative presentation. I think we should keep in mind that investors and states have different reasons for bringing annulment applications, which may be separate from the result of the annulment application as a formal process. A state buys time by bringing an annulment application, almost certainly gets to stay enforcement of the award, which buys more time and creates leverage for settlement. State officials also cover themselves, right? One of the things that I'm sure many of us see in our practice is that you may be dealing with very reasonable people on the state side. You may be dealing with people who, were not in power when whatever measure occurred happened, but politically or perhaps under their own country's law, they are at risk if they try to settle a case. And so there is, in many governments, right, there is a reason to show that you've done everything you can before paying out public funds. And so the annulment application might to some extent be ceremonial, right? I think if tribunals were more willing to order security for awards, we would see the number of annulment applications plummet. And I think we would see the investors be absolutely delighted. Investors, on the other hand, bring annulment applications by and large when it makes commercial sense to do so, which is to say when they think they will win, which is what I think is reflected in your statistics, that there are fewer applications by investors for annulment because they have to conclude that it's worth the time and the fees to do it all over again with a reasonable expectation of a better result. And so that's going to be a very powerful filter on when an annulment application is brought. So I don't think that, investors are better at spotting annullable issues than states are. I think they're acting with very different structural incentives. And so it's rational for a state very likely to bring an annulment application much more frequently.
And can I add to that? I guess the question I would raise from that, because I agree 100% with what you said, is I think sometimes in this space, in the ISDS space, we say, well, states, they want to delay, they want to get a stay, they can push it down a few years, and we all walk away and say, oh, that's fine. Is that fine?
I don't think it's fine.
Yeah,
I think we live in the world we live in,
Right,
And
right.
we can bake that to some degree into our calculations. I think it's unfortunate, and I think the more far-sighted states maybe wouldn't behave that way, right? And I think, one of the reasons that a lot of ICSID cases don't finish is because a lot of states actually do settle them. Maybe they settle discreetly, but I think the best outcome for a client is often one that doesn't involve an award.
Because a lot of the atmospheric talk in this space as well, you got these giant investors who can just, they can roll with this and they can litigate to the end. But then we're not taking account of the small investors.
Right.
The ones who are on the verge of bankruptcy because they lost their only asset in the state. They've now gone through probably a decade of litigation in that host state, and now 5 years in another process. And this is pushing them to the brink. And the state can just let's let them push it off a few more years. And I think the system has to grapple with that right now. And I think it's important to grapple with it because the regime depends on it.
Well, if we take your position, Charles, and we assume that the rate of application for annulment at ICSID is problematic, being around 50%, you've identified one way that we might deter parties from applying being to require security for costs. Another way that occurs to me is we recently saw in the Nakingwea and Tanzania case the first use of the Rule 41.5 summary judgment procedure to dismiss not, I believe, all of the annulment case, but certain claims that had been brought on annulment on the basis that they were manifestly without legal merit. Question for the panel is this something we should be making more use of, both as respondents in annulment and tribute, rather ad hoc committees? Should they be more active in applying those kind of procedures to root out frivolous or claims that have obviously a lack of legal merit, rather than having to take both parties through the full annulment procedure?
I would say yes. I mean, I think we'd all agree that time and cost are a problem in these proceedings, picking up on what Charles just said. If it's an average of 4.5 to 5 years for the underlying ICSID proceeding, and then you have at least another year with annulment, that's a long time, even if you're not a small enterprise. It's a lot of resources to put into a case. Now, I think we are going to see, we're starting to see increasing resort by tribunals to the 41.5. Those of you who read, can't remember if it's GAR or GIR, one of those publications reported just earlier this week on a couple of tribunals that exercise their authority under 41.5 to dismiss, at least in part, claims, and that's a good trend, I think. And you know, you have the ICSID rules that are carried over into annulment proceedings, mutatis mutandis, and I think 41.5 should carry over, and that annulment tribunals should, in appropriate cases, you know, exercise their discretion to use that authority. You know, it's a relatively new thing in ICSID, and like anything, it takes some time to really take hold. But I think it's something that could be used to good effect in these cases.
You know, I started my career as a litigator for many years, and now that I've been doing almost exclusively arbitration, I usually do bemoan the cost of time. I do. And I think this is both goes for commercial and investor state. One of the reasons that's driving the cost and time is tribunals just not grasping the nettle early and having the guts to do what they know they probably should do early. And this is one of the things, when the arbitrators have the tools, they also have to have the guts to use them. And it goes the same thing on stays of enforcement. I think there are probably plenty of cases where, if not this, then not imposing a stay of enforcement maybe is the way to push this forward. But again, it goes back to arbitrators and committee members in cases like these to just figure out what's in front of them and use the power at their discretion, rather than just sitting back and letting it roll for years.
I mean, I would just add, I think from the perspective of investors as much as states, 41.5 systemically is a good thing, because it gets us closer to something like motion practice. And I may be betraying a US prejudice here, but what that does is it makes the cost of these cases lower. And if you are going to lose your claim, it's much better to do so early on. And that, I think, overall increases access to justice by allowing smaller investors, medium-sized investors to bring claims. And I think it will tend to undercut some of the, in my view at least, exaggerated attacks on investment arbitration or arbitration generally. I think clients would like an efficient disposition. So first, if there is a colorable argument for 41.5, it's much better to get the bad news over with rather than go all the way through quantum submissions and heaven knows what else 5 years down the road and have the same result.
Yeah. Looking then at some of the specific grounds at ICSID on which awards have been annulled, one figure that Jack put up was the figure that around 10% of ICSID awards where the allegation is that there's been a failure to state reasons have been successful on that ground. Now that may not sound like a lot, but it still means that 1 in every 10 awards that's challenged on that basis is upheld for having, in some sense or other, failed to state the reasons on which it's based. Again, does that suggest that we are expecting too much of tribunals, even when they issue, we've all seen the 200 or 300 or 400 page awards that come out, and yet we're still finding that even then that tribunals are not addressing every issue that's been thrown at them in the course of the arbitration, or failed in some sense to state the reasons? Are we expecting too much of tribunals, do we think? And do we need to rein in a bit somehow the scrutiny that we put on making sure that they address every issue that comes up in the course of an arbitration? Lucinda, perhaps.
Well, this is a tricky one, but I'll say, David, that I'm not sure I fully agree with your premise, although we've all heard about due process paranoia and those meta universe things that are out there. But I think in stepping back and thinking about this ground, and you really have to think about it both in absolute terms and in relative terms to the other grounds. And of course, most applicants on annulment don't just raise one ground. They raise the three most frequently invoked, even though unequally successful, are often all raised, or some variant of those. But if you think about this ground in comparison to the other two that are more frequently raised, which are manifest excess of powers or serious departure from a fundamental rule of procedure, both of those in a way have significant threshold requirements that need to be met. That failure to state reasons doesn't. For manifest excess, you've got to have the excess, either infra or ultra. You've got to have the manifest nature of it. In the case of a serious departure from a fundamental rule, you've got to have the fundamental rule and the serious departure. So there are some threshold issues for both of those that you don't have for a failure to state reasons. And that gives it a potentially broader scope when you're looking at attacking an award. Now, there is also Article 48.3, of course, of the ICSID Convention, which I'll remind you reads, quote, "The award shall deal with every question submitted to the tribunal and shall state the reasons on which it is based." But this provision shouldn't be read, and I don't think it has generally been read by ad hoc committees to require the arbitral tribunal to address every single point that a party may argue in the course of a debate. Rather, the focus of many committees grappling with this ground has been on the importance the submitting party places on the issue, or what is key to the arbitrator's decision. And you'll note that this ground talks about questions. It's not every submission, and so there's a question of what is a question, but it's not necessarily the same as an issue or a submission. And of course, ad hoc committees aren't allowed to consider the correctness of the tribunal's decision. The question really is whether the reader can follow the tribunal's reasoning. As was famously said in the MINE v. Guinea case, the requirement to state reasons is satisfied as long as the award enables one to follow how the tribunal proceeded from point A to point B and eventually to its conclusion, even if it made an error of fact or law. So that is a tricky line. I can tell you, having grappled with it as a member of ad hoc committees more than once. And it leads, I can also tell you, to painstaking review of the arbitral tribunal's decision, because it is a tricky line between errors of fact of law and a failure to state reasons. And if you get into frivolous or contradictory reasons, then you may be approaching a failure to state reasons. But I think tribunals are, even though many of them are arbitrators, and they may be inclined to give tribunals the benefit of the doubt in close cases, ultimately, in my experience anyway, the focus has been on maintaining the integrity and credibility of the system, and how the award is going to measure up in the eyes of particularly the arbitration community. So, I mean, I think, yes, everybody decries awards that are 300 pages. Guess what? The submissions are also 300 pages. Yeah. And guess what? They don't narrow. The second round of memorials is often much longer than the first round of memorials. So you can't just single out the awards for this. This is a bigger problem.
This is counsel's fault. I wrote. I'm primarily counsel, and it's the counsel's fault. My colleague Luke Sabone and I wrote an article almost a decade ago now, saying that the problem with cost and duration in investor-state arbitration is the fact that parties are just filing. At the time, we'd be mown 200-page briefs. Now a 200-page brief is like an executive summary. We're seeing 800-page briefs, 1,000-page briefs. It's ridiculous. I clerked in the Third Circuit Court of Appeals right out of law school, and the famous Judge Alderswift there once said, if you come to the court with 12 assignments of error, it's a pretty good guess that you have none. And that's one thing that counsel don't do, is narrow it down, plead it concisely. You'd get a quicker award, and you'd get a better award in the process that wouldn't be subject to this. But we, as a bar, are having trouble regulating ourselves on that, and that is a problem for counsel, not necessarily the arbitrators.
Well, the arbitrators have a role too, because I think a lot of arbitrators are reluctant to put limits. I mean, you've been in federal court. Federal courts don't hesitate, or the Supreme Court, to tell you, okay, this is
50 pages.
You got to do it in this that would be salutary
I agree.
for the system.
I agree.
I do think it gets back to the 41.5 discussion, though, because in federal court, you have a whole bunch of stages
To win
that
it.
have happened first.
Yeah.
You know, you have a complaint and you have answers and you have
Yeah.
motions dismissed, partial motions dismissed, partial summary judgment motions. You've got none of that.
Yeah.
I mean, I tell my clients that you're going straight to summary judgment on everything
Yes.
because that's the closest sort of US analogy to memorial pleading. And so I think it's, yeah, sure. I think it'd be great if tribunals imposed page limits, but I think it ultimately reflects this sort of soupy procedure.
Yeah.
So another one of the grounds, the findings that jumped out at me, and one on a more positive note, is the finding that at ICSID, ground 3, corruption on the part of one or more of the arbitrators, has never even been invoked before an ad hoc committee, let alone succeeded. Is this an encouraging sign? Or perhaps it simply reflects the difficulty of either identifying arbitrator malfeasance, or even if it is identified, marshalling sufficient evidence to mount a case on that basis. What do you think, Charles?
Yeah, I think it's a great sign, obviously, and it demonstrates. I think if we step back, it demonstrates the reason for the process in the first place. You know, if investors don't have access to a credible ISDS system, where do they turn? Well, the big ones can get commercial arbitration. That's great, but let's set them to the side. The smaller investors are stuck in local courts, right? That's what they have. And did you ever look at the Transparency International map on corruption? I'm sure you have, Lucinda, right? Yeah, right? I mean, it's you know, the red are really corrupt states and the yellow are not. In the entire world, it's crimson red. It's very depressing. I think having this point for ISDS is one of the critical points why the system exists in the first place. And it's wonderful that it's been able to hold that.
A broad point for the panel. The 5 grounds for challenge of an award at ICSID haven't been changed since the convention was first agreed in the 1960s. Assuming that it were even possible to, at this point, amend the convention, which is probably about as hard as amending the US Constitution. A question for anyone on the panel, perhaps starting with you, Carlos. Would you amend any of the grounds? Would you add any, take any away, or modify any of the existing ones, perhaps to change the standard? For example, as Jack said, the requirement of a manifest error.
I personally wouldn't. I think we have, and we see this with a lot of the proposals for investor state reform, is that they're very one-sided. I think you would see exactly what we've seen with the new ICSID rules, for example, that basically, with a few exceptions, they're written by states. And I wouldn't fault states or their representatives for trying to adjust them in their interest. They're obliged to do so. But I think the rules were written, at a moment of shall we say, a vision or of globalism, which, politely put, isn't this moment. So I would leave it the hell alone, and the same for the Constitution.
I just say it.
Yeah.
You highlighted the question of amendability. I understand it takes unanimity to modify the ICSID convention. So I don't favor amending the Constitution either. But although there might be a couple things that I would do. But yeah, I think the one I think about the most is public policy and whether there should be a public policy defense. And I mean, public policy comes into these awards in funny ways. Anyway, you see it sometimes coming into legality discussions. Think about the ICSID case, for instance. You sometimes think of it comes in sometimes with admissibility issues. So it's lurking there. But that's the one I think would be the strongest contender if we were to embark on this project. Now, obviously, it would be international or transnational public policy, and that brings you to the whole question of what is that animal? I'm sure you talk about this with your students, Charles, and it's a pretty mushy thing. Talk about mushiness, Carlos. So it's not easy, but to me that would be the strongest candidate.
Looking turning away from the substantive grounds of annulment and looking more at the procedure, we had a similar talk at Dubai Arbitration Week late last year on the ICSID and non-ICSID annulment proceedings, and Professor Jan Paulsen, who was one of our speakers, expressed a very strong view. It's fair to say that in his view, ICSID annulment proceedings are not at all applying the spirit of the procedure when it was first devised. That not only was it meant to be an exceptional remedy, but that the procedure for an annulment proceeding ought also to be expedited and much simpler than the process that it's often turned out to be, which effectively replicates the arbitration process, right? You often have several rounds of written submissions followed by a hearing, and the annulment procedure alone can take a significant amount of the time that the underlying arbitration would have. So a question again for the panel, is there more we can do to rein in, or should we even rein in, the way that annulment proceedings are operated procedurally, bearing in mind, as you mentioned earlier, Lucinda, that the ICSID rules effectively encourage this by stating that the arbitration rules ought to apply mutatis mutandis to an annulment proceeding. Is that the right approach, or should we be somehow trying to confine the process procedurally?
I mean, it should not shock anyone. I agree with Jan, and that's not just because I have to as a 3 Crowns employee. It's not in my employment contract. But I think that it comes down to the committees just being able to get a procedural handle on these cases. I mean, in all sorts of arbitrations, I'd love to see a committee, I'd love to see a tribunal come in and say, okay, we've read everything, we have 3 questions, we have 3 issues here, and I want really tight briefing on these 3 issues before we get on with it. I would love to see something more like that. Do we have to amend the rules for that? Maybe. Or do we just have to have tribunal members who are willing to do it? I think that's my overriding theme in response to that.
I mean, I think the rules do nudge in the direction that you indicated, David. And I think there's mission creep to some extent that go on. Virtually every annulment case I've been involved with, maybe with one exception, one of the parties has sought to introduce new evidence to bolster their claims, new witnesses, new documents, new expert testimony, and they're related to the grounds for annulment, but it has the effect of making the procedure even more involved. And of course, it's hard for them to say, no, we don't want to have a hearing. Right. But I think a lot of these cases could be resolved. Yeah. Not only early, we talked about the use of the 41.5 tool, but on even if you don't do 41.5 on the pleadings, do you really need hearings, especially if you don't have new evidence? I mean, personally, I like hearings to be able to kind of tease out some of the key issues, but I'm not sure if you're really trying to make the process more efficient that you need them in the annulment context.
All right, well, unfortunately, we're almost out of time, but just to turn very briefly to look at the non-ICSID side of the research. As Jack's findings earlier showed, there's not only a significant difference between outcomes at ICSID and before national courts, but also quite a wide variance, although bearing in mind the relatively small sample size, between outcomes in different national jurisdictions. I think Jack showed there was a success rate of around 56% before the English courts, compared to a 25% in the Swedish courts, compared to the US, whereas as far as we know, an investor state award has never been annulled out of some 11 vacatur proceedings. So a question again for the panel, does this just simply reflect a difference in legal cultures? Are the English courts too eager to interfere? Or are the American courts perhaps too deferential, this famous pro-arbitration bias? Any thoughts on why we're seeing such divergent outcomes?
I can start. I think that we're celebrating a statistical study, but the numbers of cases are still very low. I would speculate that you have more varied results in the English courts because you probably have, and you guys have the stats and I don't, but you probably have more non-ICSID investor state cases seated there. Yeah. Whereas I would think that most of the US cases you have are ICSID cases, which, or if you have an ICSID additional facility case, I suppose it's seated down the street, but otherwise they're here because they're ICSID cases. And so I think you simply have more of these issues probably arising in England or in other European jurisdictions first. I don't know if that's actually what your data show, but that's what I would infer.
Other thoughts?
I'm not going to venture into anything comparative. I mean, when I thought about the way you framed your question, I immediately thought of Winston Churchill, two countries divided by a common language. And, yeah, there are certainly the judicial systems are different, but Carlos may be right in terms of the nature of the underlying cases, which is important. I don't think it's culture. I think it's law. I think it's policy. I mean, the U.S. has a very strong policy, but and we also have things like, as we know, in cases involving sovereigns, statutes like the Foreign Sovereign Immunities Act, which add to the pro-arbitration tilt of U.S. courts hearing actions involving foreign sovereigns. So I'd just say that I don't think it's culture. I think it's other things.
Yeah, I'll add, but this is purely anecdotal. Having done both ICSID, non-ICSID, set aside in England, I've never had a non-ICSID ISDS seated here. I've been 20 years. I just never even. I think it comes down to this. ISDS cases are different than what a judge's regular diet is, right? They just look at it and say, I have a fair and equitable treatment claim that awarded sunk costs in some foreign country. I think the English judge's initial reaction is, I'm going to analogize this to what I am used to, right? And that leads to looking at causation. That was very different. Looking at valuation. That is very different. Looking at these opaque standards that I don't quite understand, but I'm going to put it into a commercial box and I'm going to try to make it work. And often it doesn't work. I think that the U.S. judge's view, having clerked for U.S. judges, to sort of say, yeah, I'm way over my skis here. We're going to go to deference. That's sort of my view, because I think there is, and I wrote an article on this about a year ago. There is truly a liberal federal policy in favor of international arbitration here in the United States, and it's very strong. And the Supreme Court has been pushing very, very consistently on that over the past decade and a half. And I don't see that changing, to be frank with you. So that's just my anecdotal observations.
I think to Carlos, to your point, which is a good one, Jack will correct me if I'm wrong, but I think of the 11 annulment proceedings that have taken place here in the States, 10 of them were before the DC court. So 10 of those 11 investor state arbitrations were seated here in DC. One, I think, was before the SDNY. So when you look at the rate there, what you're really talking about is the approach of the DC courts, not of the American courts, federal as a whole. All right. Well, I think unfortunately we're probably out of time. So I think because I'm conscious we have another panel at 4 o'clock. So, and probably you want some refreshments in the meantime. So I think we'll cut it short there. But please, I'm sure you'll join me in thanking the panel for what's been Lucinda. Yeah.
Oh, I was just going to say, are there any questions? What?
Just have one, and it's technical. First of all, great work on the study. I know how much time it takes to do these studies, so really appreciate it. When you last shared the results as part of Dubai Arbitration Week in November, I agreed with all of the non-ICSID percentages. Presenting it now, there's been a variance of between 1% to 3% for Sweden, for the Netherlands, and for France. But England has changed by about 30 to 40%. And because last time it was at 20%, now it's at 54%. And I'm quite familiar with the number of cases before the English courts, and that doesn't resonate with me. So I'm curious as to, because I know there have been some set-aside decisions recently, but many of them have not invalidated the award. So that in some of them you still have a claimant that has access to the full award proceeds, but one claimant has been dismissed. But I'm curious to see what the rationale was and the explanation for the difference between 20% to now 54%. And it could have just been a data issue, but 54 seems high. I mean, the UK to me is a safe jurisdiction, and 54 makes it seem very unsafe.
Yeah.
So there have been a number of successful applications. I think what this comes down to is the way we have to categorize what is successful or not. So for some of them, if, for example, if there were 6 claims and only one of them got annulled, we still counted that as successful because
in part, yeah.
In part, obviously, so we obviously break down between partial annulment and full.
Yeah.
But if the courts have, I guess our threshold was, have the courts stepped in and said the tribunal got it wrong? And so if they did, we would chalk that up as a partial set aside. So I think the combination of that approach, a number of decisions that have been rendered in the last 6 months, obviously which have been captured post the Dubai event, and then third, I think just the fact that as you say, it's a very small sample size with the English decisions. I think those are the 3 factors which have, as you say, swung the numbers quite considerably high.
I'd like to say, obviously, I may be proved wrong, but I think today, obviously, Jack had to do some pretty general kind of statistics. As you point out, Jeffrey, I think some of the graphs, can be interpreted in different ways. I think the ultimate report will break that down a bit more, right, Jack, into partial annulments, full annulments, which I think gives you a more kind of nuanced view of those statistics.
Yeah, I just think it'd be useful to have an asterisk or something to explain, because for the UK, the 50% figure.
It seems strikingly high, doesn't it?
I mean, we have our own figures, and the UK is nowhere near that.
Right,
so.
right. Right. Well, if that nuance is not in the report, I'm sure it will be by the release in December. I'm told by the higher-ups we do actually have time. I was wrong. We have time for one more question if anyone in the audience has anything burning that they would like to ask the panel or Jack.
Hi, my name is Shreya. Thank you so much for the discussion. It was very interesting, and even the numbers. When I think of annulment grounds, I mostly think of them as really rare. Lucinda, you touched upon it a little bit. When you think of grounds like public policy or or review, it's really great. There are no guidelines on how to read what public policy might be. And then even in the ICSID grounds, manifest error and fundamental error and things like that. They're very gray and broad. Do you think there's value in institutions giving guidelines on how to interpret this, or do you think they should remain broad because they can be a fact-to-fact kind of application? Just curious to see what the panel thinks about it. Thanks.
It's a question I thought about in preparing for this panel. And I was looking back at the ICSID annulment paper. I mean, they do really digest the cases and they go through ground by ground, and you can get a flavor of how they've been interpreted by annulment panels. So there is that kind of resource that's available to ad hoc committees when they're dealing with these issues. Would more guidance be appropriate? Possibly. I mean, it takes us back to our initial discussion about why are there so many of these.
Yeah. I go back to what Carlos said about not opening this Pandora's box up. I've sat in UNCITRAL Working Group 3 meetings where they're trying to reform the investor state system, where every state in the world, no investors, are there doing it. It's like watching tobacco companies debate tort reform. Let's be honest. Right? And if they start redefining things, it's going to go one way, right? On the other side, the openness of it, the open texturedness of it, allows the arbitrators, who are supposed to be the ones who are the gatekeepers in this system, to define it as they see fit. This is somewhere where I guess I'm channeling my inner RBG, and that we need a living constitution on the ICSID convention. I think that's really true.
One more, if it's quick.
Yeah, I just want to listen a little bit more about how, like, the committee handle with the corruption issue. Like, for example, if the investment is without from unclean hands or like some like corruption transaction, so how it ended with like ethics about like announcements or not so much.
So the good news is that yeah, sure. So I think, correct me if I'm wrong, I think the question was how have ad hoc annulment committees addressed issues of corruption, either on the part of the arbitrator or perhaps the parties, I assume. The good news, as we touched on, is that has never, to our knowledge, been raised as a ground for challenging an award in the ICSID system. As Charles explained, I think that's got to be a favourable sign that that the system is working as it should. Obviously, there have been plenty of challenges to arbitrators, some of them successful. Although, again, I don't have the statistics to hand, but I venture to say that the vast majority, if not all of those challenges, have been more for issues around conflicts of interest, either actual or perceived, and not corruption or misfeasance per se.
If I could just comment on that. So corruption issues are not dealt with directly in the ICSID annulment system, except for what David just said, which I don't think was, I had trouble hearing your question, but I don't think that was the thrust of your question. So say there's an allegation that there was corruption in the making of the investment or in the performance of the investment. If it's in the making of the investment, that's likely to come up in the ICSID system under the underlying instrument, the BIT or whatever it is, through an express or implied legality clause, which will look at legality typically under the host country's law at the time of the making of the investment, and and every local law has anti-corruption rules, and there have been a number of cases that have dismissed on jurisdictional grounds claims based on the legality clause. And then you also have claims or cases that have where the inadmissibility of one or more claims has been found. So those are the way the ICSID system puts it. So you could potentially deal with those determinations indirectly in the annulment process, but it would have to be through one of the annulment grounds, not as a direct issue, because you don't have public policy, as we talked